car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Hello, I'm Art Franklin, your host for The Attorneys. We want to thank you for joining us. Perhaps we all should be asking this question: what happens to my stuff when I die? That's a topic, and we're going to unpack that in just a moment. But first, a reminder that Hollis Wright has attorneys standing by live right now, and you can call them at 1-844-LAW-TALK. That call is free, and it is a confidential call, and they're waiting to hear from you. We are looking forward to talking to Yawanna McDonald. Again, the topic: what happens to my stuff when I die, Josh?
This is as relevant to you as it is to me, as to everybody sitting on their couch right now. It's a super relevant topic. I thought one of the interesting things in just kind of preparing for this show that Yawanna provided us was a comment that this is a gift to your family, which is a will, or at least estate planning in general terms. So we're super excited to have you on to be able to unwrap this topic and talk about it. How did you get into this area of the law? Because it's complicated, and not everyone does this type of work. I certainly do not. Tell me a little bit about how you kind of got into it and how you gravitated towards wills and estates and those types of things.
Thank you for having me today. I really fell into it and found that I had a passion for it. It is very personal. It connects you to families that you're representing. It's very interesting to me how a decedent or a testator decides who gets what. And it comes down to a lot of times family dynamics. And so it was fascinating to me to figure out why mom gave X to someone and not to a daughter or to someone else. And sometimes, a lot of times, the family dynamics play into that. Yeah. And so it's very interesting, more than a simple contract issue.
I have found over the years in the legal world, and it sounds like you found it too, is sometimes something seeks you, you don't seek it in the legal world. It's kind of like we talk about, I do a lot of dram shop litigation, and I didn't go seeking it. It kind of came to me with a series of cases and a life event that happened that impacted my desire to get involved in that. It sounds very similar. Tell us a little bit about your firm and kind of what your firm generally specializes in. I know this is one of your specialties, but a little bit about your firm and what your firm specializes in.
Yes, so my firm is Campbell Partners. We're located downtown Birmingham. Our practice area specializes in shareholder issues, meaning people that are partners in a company and they are now having a dispute. We handle a lot of those issues, security issues relative to if you're investing and something goes wrong or awry with your investment or your investment advisor. We handle a lot of that litigation. And then, of course, we do a lot of trust and estate litigation, which is what I focus on. So
let's talk a little bit about people can, when they pass away, they have choices before they pass away. About whether they're going to have some type of estate plan and for example, create a will, or if they're going to die without an estate plan and the state government has defined kind of what happens to your stuff. Let's unwrap that side first. So what happens if someone does pass away without a will? How does the legislature kind of handle that for people?
Yes, so the legislator has already chosen the path to which how your assets will pass. So, and who gets those assets. And particularly people need to understand that the legislator also gives an option for your creditors to serve as an administrator of your estate. When you don't pick who you want to oversee your assets, the legislator will do that job for you. And oftentimes it costs more, particularly people that don't have a will when they die. The administrator of their estate has to be bonded. And so though that's an extra cost to the estate, a bond, that person has to be credit worthy. They have to be approved by the court. So there are a lot of additional steps when you don't have a will in place.
So we deal, unfortunately, in a lot of our cases are in circumstances where someone passed away without an estate plan, without a will, And, Alabama has intestate succession, which defines basically how your assets are defined. A lot of what we've been talking about is exactly what we're doing, which is finding an administrator that is able to serve, making sure they're creditworthy, they're bonded, et cetera. It's a complicated process that you've got to go through.
Complicated indeed, and just listening to what happens with the legislature is in control makes it very difficult for a family when that happens. This just happens to be something that we're going through and just really completed as early as last week. In my family, my mom's 97 years old, and she wanted to make sure that everything was in order, so she wanted to make some changes. And so when it's difficult, when you don't do that, it can be relatively easy, I would think, because it certainly has been easy for us. And she's in her right mind. She knows what she wants. The lawyer sat down, talked with her individually, talked with us together, because he wanted to make sure that she was able to make those decisions herself. But it certainly makes it easier for a family if you do it on the front end, right?
That is correct. And what your family did for your mama and her undertaking that to make sure that she's getting those things in place is a gift. Because when the family has to go through figuring out who's going to serve in those positions, what are the assets, where are they at, that's on top of your grief. You are grieving the death of your loved one, and so now you have to figure out a playbook. Whereas when they do the will, do the estate planning, they've given you the playbook. It's only the execution for the family members that are left behind. So it's very important for those family members to connect and talk about these things. A lot of times people don't want to talk about it. We're afraid to talk about it, think it's bad luck or anything like that, and it ends up costing us a lot on the back end.
And Josh, we learned out so much. You learned so many things about the assets as to where they are, who they're going to on that side of it, as opposed to the problems that you'd have.
Well, that's right. And part of the will process also is giving the future decedent an opportunity to direct where they think their assets should go and to create a plan. There are, and we can talk about this after the first break, there are certain types of assets that are beneficiary-based assets or distribution-based assets where they never hit your estate, they never touch creditors. Creditors can't get access to them. And we can talk and kind of unwrap that a little bit more. But one of the questions I wanted to ask Yawanna was really just a basic question, which is, how does someone get started? Like, is it as simple as contacting someone like you and saying, hey, look, I want to sit down and kind of give you our life and explain a little bit about our family so that we can start to put together some type of will?
Yes, I would encourage anyone out there that has some questions about their estate planning, contact a lawyer. Oftentimes, people believe that they can go online and create these wills or documents online, and then they're not valid. They have questions, and they don't have a lawyer readily available to answer those questions. So yes, they should contact a lawyer to help them prepare a will.
When we go to break, because I know we're about to go out to break, when we come back, I do want to talk a little bit about how you can prevent creditors from really grabbing assets in an estate by making the right decisions on the front end before someone passes away.
That sounds like a good place to start. When we come back after the break, we want to know what happens to my stuff when I die. That is the topic that we're dealing with right now. We want to remind you that you can stay in touch with us anytime throughout the week by getting in contact with Hollis Wright on its social media platforms, on Twitter, on Facebook, on YouTube. We got stuff there all along. Great information, not only about this topic, but other topics that you can get along with us and find out what's going on throughout the week. Right now, call an attorney at 1-844-LAW-TALK. They are standing by live. We still have a lot to do right here on this show to talk about what happens to my stuff when I die. Great conversation. Stay with us. We'll be back with the attorneys right after this break.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the Attorneys. At Hollis Wright, we don't make empty promises. So here's a promise you can bank on. If you've been injured in an accident and want tough, aggressive, and relentless representation that wins a lot, you'll get it at Hollis Wright, where your result matters.
We welcome you back to The Attorneys, and we are talking with Yawanna McDonald, and the topic is what happens to my stuff when I die. So much to unpack with this one, Josh. That's why I wanted to jump right back into it, and you set us up right before the break.
Yeah, let's talk, Yawanna, just for a second about some of the avenues people have to make sure that their assets at the time of their passing do not get kind of caught up with creditor claims for debts that are part of the estate too.
Yeah, so a part of that, what you do is bank accounts or 401k, your investments, those have designations for beneficiaries. And so when you open those accounts, you have the opportunity there to list a beneficiary for that account upon your death. And so those are payable upon death or transfer upon death type of accounts. And so those type of things, accounts, go outside of the estate. Upon the decedent's death, that person would simply contact that entity and let them know, make them aware that the account holder is deceased. And if they are the beneficiary, they'll fill out some forms and receive the proceeds. And so it's a wonderful way of going outside of the probate and not have to be subjected to certain creditors by doing that. Insurance policies are another item. Where the beneficiary is listed by name, then they will receive those assets.
And the drawback to not focusing on things like this, because this really is part of an estate plan, is that if someone has a sizable debt, in theory, if you don't have a beneficiary distribution or you don't have a will, creditors would be able to attach to some of those resources and assets so that your loved ones would not be able to receive those. Is that fair?
That is correct. So where on those accounts you don't have anyone listed, or perhaps you have a wife or a spouse that's listed there and that person predeceases you, and you never go back, a pension account, and you never go back to change it from the surviving spouse that you originally listed and they are now deceased prior to you, then that's going to fall to your estate if you have no contingent beneficiary or secondary beneficiary listed.
Art, this is a really good point too, is for those that have purchased a home, they will ask you whether or not you want to purchase the home joint purchase right of survivorship, and that is another mechanism that allows for your property to flow outside the estate, not be subject to creditors, where if you pass away, your wife immediately gets title or has to jump through a couple hoops, but will get title, and that will actually not go through your estate. Whereas if you didn't do that, then you bought it individually and it was not a joint right of survivor on the deed itself, that could get pulled directly into your estate and be subject to creditors, where in theory someone would have to sell a piece of property in order to get the assets to be able to pay the creditors off. So this is a shining example of why you want to have someone who understands this law kind of lead, guide, and direct you through the process.
Talking about someone understanding it and then having beneficiaries on a policy like an insurance policy, is that why what Josh is talking about, where you don't want to have a minor on that policy?
Oh, absolutely. A minor isn't capable of ascertaining or knowing what to do with large sums of money, right? And so a credible insurance company would not readily give a minor a check for hundreds of thousands of dollars just because they're noted as the beneficiary on there. And so in that cases where people have put minors, they sometimes have to go to court and ask the judge for permission or direction as to what's the next steps, what can we do here? So it's most prominent for a person to put an adult that is going to care for that minor as the beneficiary or set it up as a trust. They can have the policy paid to a trust, and for that trust be for the benefit of the minor. So there are different ways for that to happen, to navigate those methods so that the child can get the benefits of the policy. But it's best to talk to an attorney about that, to help guide you through that, to put in some parameters to help that family navigate through that hard time.
You want to talk a little bit about the process in making sure that a will is actually enforceable down the road. There are certain things that you've got to make sure that you do, because I know a lot of people, I hear from a lot of my clients, well, I pulled something offline and I signed it and I've got it in a safe deposit box. Well, that may not be enough in order for that will down the road to be enforceable.
Yes. So in Alabama, a will has to be enforced, but one, it has to be valid with witnesses, signed by the testator or the testator or at the testator's direction. Additionally, that person making the will, the testator, has to be competent. They have to know that they are putting a will into place. They have to know their assets. And then lastly, we would like that will to be uninfluenced, meaning that testator knows what they're doing and they're not being influenced by someone else to leave assets a certain way or not a certain way. So those three things should align together to be a valid will. And then of course we need the original will. Yeah. And so you should tell your loved ones where you're putting that document, how they can access the important documents upon your death, so that they, again, grieving, don't have to jump through extra hoops to find those documents.
This is so good, Yawanna. So good hearing this information. But why do people delay in doing something as simple as that, putting together that will?
Fear. Fear of the unknown. Also, sometimes people want to delay conflict with family. They have choices that they need to make, hard choices. Who should be over the estate? Not every child or spouse should be over the person's estate. Who's the best one? You should look at that. Even if it's outside of the family, it could be a friend, but it needs someone responsible that is going to execute your game plan. That's what you need. So people are fearful. They want to avoid conflict. And sometimes they think it's going to cost me too much money. So I can't do that right now. And so, again, they avoid doing it. But all those things can be overcome with the right lawyer. And it's better to face it now rather than to leave your family trying to pick up the pieces.
Yeah, and one of the things I want to talk about when we come back, Art, is I want to talk a little bit about part of drafting a will also allows you to define who you want to be the kind of in charge as your representative to administer your will correctly, and how important that can be to find someone that is not going to be emotionally charged, is going to make objective decisions and properly carry out your kind of last desires.
All right, we will get into that when we come back, but we want to take a break. As we go to break, a reminder to you that Hollis Wright has attorneys standing by live. These attorneys you can talk to right now. It won't cost you anything. It's a confidential conversation. All you have to do is call 1-844-LAW-TALK and you can reach an attorney from Hollis Wright right now. We're going to take a break. We've got a great discussion going on. We'll be back after this.
I'm attorney Carter Clay with Hollis Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys.
Did you know we have nearly 100 5-star reviews on Google? That's because our clients like the work we do. If you've been injured in an accident, we are here to help. Give us a call for a free consultation. At Hollis Wright, your result matters.
We are back, and you are watching The Attorneys, and our special guest is Yawanna McDonald, and we are addressing what happens to my stuff when I die.
So Yawanna, let's talk. When we went out to break, I mentioned I want to talk a little bit about the fact that when you have an estate plan and have a will, one of the things you can do is decide and determine who is going to be responsible for carrying out that will, which is an important component to the will itself. Talk a little bit about that and the importance of that person.
Yeah, that role that that person fills is known as the personal representative. Sometimes people call them executor. And if you die without a will, it's an administrator. But it's the same role for all three titles. And that person is someone that has a duty to the estate, right? So they are trusted to follow the will, or to follow the steps that the court outlines for them to do to administer the estate. So if your will gives X amount to a spouse, they are to carry that out and make sure that that person gets the money. And so they also have a responsibility to let the heirs or the beneficiaries know what's going on in the estate. Oftentimes, most beneficiaries don't know what's going on, and so that causes some issues down the road. But if that person is very responsive to questions and provide more information, accounting, for example, about the estate and what's in the estate, that helps go along a long way. So the personal representative is very important. If you die without a will, that person would need to be bonded, credit worthy. A lot of times people don't think about that when they don't have a will, and it gets hard to find someone. And of course, if you don't have anyone that can be bonded for the intestate estate, then of course the county administrator can administer that for you. But you would like for someone in the family or close friend to be able to administer the estate. And so it's important for a personal representative to give some thought into that when you're nominating that person.
And if you've got a will, you can waive some bonding requirements and waive those things, and you can still define an individual to serve as the personal representative or executor.
That's right. So in your will, you should, well, I would advise that you waive a bond. Any person that you're putting in place to handle your assets, they should be trustworthy enough that they don't need a bond.
One of the things that Yawanna mentioned early on that is really important is if you don't have a will or an estate instrument in some respect, creditors actually can take over and can administer your estate, which is kind of a worst case scenario. So this is a way to eliminate that from being an issue too.
That's right, Josh. As you were saying that, what I was thinking about is what types of things should be in a will because of that or shouldn't be in a will.
Well, we've already talked about some accounts that you can exclude from the will, insurance that you can exclude from the will by having designated beneficiaries on that. Most times your house, as Josh mentioned earlier, right of survivorship, and so it would go to your spouse upon your death. So there are things like personal property that we call like things such as jewelry, clothing, art, vehicles, things like that that you have at your house that are worth a lot, boats, anything like that, any land that you have. If you don't do a deed with right of survivorship, that house should be in your will. You should designate who you want to receive that house upon your death.
I don't want to get too complicated for what we're talking about in this show, but I know that you deal with this at times, so I thought I'd mention. Are there ways, let's say you've got a child that is struggling a little bit during your lifetime, you want to assist them as best you can, but you want the assist that you're providing them to be taken into consideration at the time of your passing. You've got, so if you're, let's say you're advancing money to someone to help them or advancing a house to them, but you want everyone to be treated fairly at your passing. Those are things that can be written into your will instrument too, are they not?
Exactly. You can account for the gifts that you're giving now for later. You can account for that. And if you have a child that has special needs, or you have a child or someone that's struggling and you know they're going to need some help along the way, you can account for that in wills and trust documents. And so there are attorneys out there that can do wonderful jobs with helping assisting that.
Is it inappropriate, or do you at least see circumstances where someone's a little intimidated to go to a lawyer related to the financial side of drafting a will, where they ask you about, hey, can this be done on a budget? Can I kind of understand what it's going to cost to do that? Does that offend you, or is that just part of the process of being a lawyer?
That's part of the process of being a lawyer.
So don't be offended.
Don't be offended.
That's right. And call someone if you want to do a will. You want to be able to call someone.
Yep.
Thank you for being on. This has been great. Super helpful.
Yawanna McDonald, thank you so much. And again, Josh, thank you. And he mentioned about calling. You can call right now, 1-844-LAW-TALK, and reach an attorney from Hollis, Wright. We thank you so much for joining us. Look forward to you joining us next week. Same place, same time for the attorneys.
Thanks for watching The Attorneys, sponsored by Hollis, Wright.